Good morning and welcome to the ICC United Kingdom Annual Arbitration and ADR Conference 2024. This year we're starting with day one, which consists of 3 webinars, and today kicking us off nicely are the YAAF network, so the Young Arbitration and ADR Forum, and our 2 UK representatives, Nora and Trisha, who are kindly putting this webinar on for our audience today. We have over 400 people registered for the 2-day conference, which is fantastic. And so tomorrow is in person. You have until lunchtime today to register if you haven't done so already for tomorrow. We can take some last minute bookings, but we are reaching full capacity. We also have a really exciting hackathon that's being organised by Jasmundi and Arbtech tomorrow in person, which consists of 30 people sort of mastering their AI skills and then presenting to a selection of judges. So all very exciting over the next couple of days. Just a quick thank you to all of our sponsors and our supporters. We wouldn't be able to do it without you. So thank you very much for your help. You'll see them on your screens. We have EY, who have been gold sponsors for the last 2 years. So thank you ever so much, EY. 39 Essex Chambers, Jasmundi, Charleview, who are our silver sponsors, Latham & Watkins as bronze sponsors, and then our event host for tomorrow, Simmons & Simmons. So without further ado, I'd like to hand over to our YAAF representatives, Trisha Mitra-Veber and Nora Fredstie, to take things forward. Thank you, ladies.
Thank you very much, Natalie. Good morning, everyone. I am the new YAAF representative, along with Trisha Mitra-Veber, based here in London. And we're delighted to be organizing this first webinar of the ICC Annual Arbitration and ADR Conference, which I take as a great sign that the ICC UK is placing new talent up front and center. Now, ICC YAAF rarely requires any introduction, but in case we have somebody who's very new to our profession, the ICC YAAF is a global network that's open to a young practitioner and is probably the largest network of its kind. It offers networking opportunities and skills developments through, for example, events like this on the first appointments, and also gives you an insight into potential careers in international arbitration. And on that topic, we are hosting another event on the 5th of November, where we interview Claudia Salomon on her career and her advice for young arbitration practitioners. I will put the link to that event in the chat box, so feel free to register to that as well. But back to today. Today we will talk about first appointments, and I will hand over to Trisha to introduce our panel.
Thank you, Nora. For those of you who've been following the ICC YAAF events, there have been a few sessions on securing your first appointment. So we thought we would bring to you a panel about what happens once you have secured your first or your even initial appointments. So what should a first-time arbitrator expect once they've been appointed? What are some of the naughty procedural issues that can arise? Who can you seek advice from if you are sitting on a sole arbitrator? So we've gathered a fantastic lineup of speakers for you today who will talk to us about some of their learnings from their initial appointments and even share some war stories. Our moderator for today's webinar will be Krystle, who will be guiding us through the discussion. Krystle is an English and French qualified senior associate in the London office of LALIVE. She has worked on international commercial and investment arbitrations under all major institution rules. She's also acted as tribunal secretary in LCIA and FAI cases. And then we have speakers from all across Europe and the UK. So I'm going to go in the order of the tiles on my screen. So starting with Anina Liebkind, who is a Stockholm-based advocate and arbitrator with over 15 years of experience in dispute resolution. She's a partner of the Stockholm-based disputes firm Norburg and Scherp, who is one of the biggest disputes team in Sweden and focuses on arbitration and litigation proceedings. Anina is dual qualified in Sweden and Finland and serves as a board member of the FAI, a board member of the Swedish Women in Arbitration Network, and is also a faculty member of the Delos Advocacy Training Program and a visiting lecturer for the ICAL LLM program. Next on my screen is Rahul Donde, who has his own independent arbitration practice, RD Disputes Resolution, in Geneva, Switzerland. Rahul has sat as an arbitrator in multiple ad hoc and institutional arbitrations including the ICC, LCIA, MCIA, and SIAC. Next up is Krystal Baptista. So we have two Krystals on our panel today. But Krystal Baptista is an arbitrator and founding partner of KB International Law and Arbitration based in Madrid, Spain. Krystal works as an arbitrator in commercial and investment arbitrations and also sits on dispute resolution boards. Krystal is the Secretary General of the Spanish and Ibero-American Arbitration Club, and in 2022 was added to the list of potential arbitrators in treaty-based disputes between the EU and third countries by the European Commission. She's also an associate professor at IE Law School in Madrid and a member of both the Madrid Bar Association and the New York Bar. And last but not least, our very own Tomas Vail, who is based in London and is the founder of Vail Dispute Resolution, a disputes boutique representing parties in investor-state arbitrations and commercial arbitrations. Tomas's boutique has been consistently recognized by Chambers, Legal 500, and Who's Who Legal. Tomas is UK and US qualified and is fluent in English, Russian, and French. And so Tomas regularly sits as an arbitrator and is also a fellow of the Chartered Institute of Arbitrators. I think with that, I will hand over to Krystal and the rest of the speakers and cannot wait to hear what they have to say.
Thank you very much to Nora and Trisha for the introductions and for the invite to participate in today's webinar. Before kicking off properly, I thought we could start by a few words on each panelist's first arbitrator appointment, just to give the audience a flavor of how they were appointed and what sort of cases they were. First up is my much more illustrious namesake. Krystal's first appointment was in 2017 at the Madrid Court of Arbitration, where she sat as a sole arbitrator in a Spanish law case seated in Madrid. So in her words, it was quite a sort of vanilla case, but a bit of an easing into the arbitrator world. Next, we have Tomas. His first case was won as a sole arbitrator in a manufacturing supply dispute under the SCC arbitration rules. And it involved the CISG, English, and Kazakh law, so a bit of a mixed bag there with a Stockholm seat. We also have Anina, who received her first appointment in 2020, where she was sole arbitrator. We see a trend here, and was appointed by parties under the FAI rules. So Anina told us that the case seemed straightforward enough until, as is often the case, the parties started submitting evidence at times that were not agreed upon and pushing past the cutoff date, arguing that they've uncovered new smoking gun evidence. And according to Anina, a full week of in-person hearing alone with various fact and expert witnesses on both sides felt like a true initiation into the trade. Last but not least, we have Rahul, who received his first appointment from ICC some 7 years ago, and is the youngest Indian arbitrator ever appointed by the ICC. And he's got a great story, so thanks to Rahul for letting me tell it. The dispute involved the construction of a granary in Kenya by an Italian company and is very memorable for a sensitive procedural issue that arose. Should a hearing set many months in advance be rescheduled a few weeks shortly before the hearing, The reason being that the star witness was pregnant and expected to deliver shortly before the hearing. The pregnancy should surely, I think, have been known together with the due date by the party seeking the adjournment. So please feel free to comment in the chat as to what you think, whether that's reasonable or not for the hearing to be postponed or rescheduled. One final word from me before we start. There is a Q&A button on the screen for any questions you may have for our panelists. Please do not hesitate to make use of it, and we will do our best to get to them before the end of the session. With that, we will first, we'll kick off with some questions for the panelists on the initial steps following an appointment, so including the preparation of procedural order number 1. So Rahul, perhaps you could take us to the preparation of the first CMC and the procedural order discussion once the tribunal has been constituted. Aside from reading the papers, are there any particular issues you might want to raise with the parties?
Sure. Thank you. Thank you to the ICC UK and the ICC YAAF for this invitation. Very happy to be here and speak on a topic which is, I think, of interest to a large number of people. It's been many years since I've had my first appointment, but in a way, every appointment feels like the first one, right? There's always new issues, potentially new institutions, new ad hoc scenarios. So it's it's an experience I feel that is self-repeating. To answer your question immediately, Krystal, I think that there are 3 things that I like to keep in mind when I'm issuing, like, let's say, the first communication to the parties. 1, you have to know the file. So read all of the documentation that you've received either directly from the parties or from the institution in and out, including the exhibits, because you might have something important, something urgent in that correspondence, in that communication, in those exhibits that you might need to address right from the get-go. So you need to read the file well and thoroughly before you even write your first communication to the parties. The second, and this I strongly encourage everyone to do, is to familiarize yourself with the applicable procedural rules. You might have had multiple ICC appointments, multiple ICC involvements in the past, whether as counsel, tribunal secretary, or otherwise, but you'll be surprised that when you read the rules, you will often find yourself coming across new points that you might think apply in the particular factual circumstances of the case. Most of these institutions also have come out with guidance notes and instruments like that. Please read those as well, because they will, if nothing else, give you a sense of confidence when you're writing the first communication to the parties. And the third thing is to write to the parties in your first communication to say that whatever the rest of the contents are, that you're that you would like to hold a case management conference, or that you'd like to issue a procedural order number 1. Besides all of that, which we'll come across, I think, subsequently, I like to add in a line that asks, that tells the parties that in case there is anything of urgency that they would like to discuss, they should always feel free to write to me. When you receive the your first appointment, it's likely in a case which doesn't have a large amount in dispute, which potentially means that you have counsel before you that are not very sophisticated, and they might not know entirely of all of the flexibilities that an arbitration proceeding allows for or involves. So unless you signal to them that there are certain options available, they might not know it, right? So I find it always useful to state that in case there is something that they would like to discuss, or if they need directions on something, they are free to write to me. Even before the first kind of CMC is scheduled, even before the draft of the procedural order number 1, if there is to be one, is circulated. So 3 simple points: read the file, read the rules, and ask and signal to the parties that you're available to discuss anything that might be of immediate urgency, or immediately urgent or important.
Thank you very much, Rahul. That's very useful 3 points to remember. And if we're talking about the PO1, now we love to say that arbitration is a tailor-made solution to disputes, but we do have our templates, we do have our precedents. Do you use a standard PO1 template? And if so, what are some of the considerations that you might take into account in adapting the template to each case? Krystal, perhaps you might want to share some of your thoughts with us on this.
Sure. Thank you, Krystal. And thanks so much to the ICC for having me today at this discussion. I do have a template for a PO1, which I tailor for each of the cases. I don't think I've ever been able to use it as I have it, which is a good thing, right? Because after the parties have commented, it really becomes the document for that case and not a generic document. And normally, most of the parties' discussions regarding PO1 have to do with agreeing with to the procedural calendar. And the usual discussions include number and amount of written submissions, the date, content, and filing of those submissions, the rules and the dates for bifurcation or trifurcation of the proceedings, whether there's going to be document production or not, organization of the hearing, including whether the parties think that there will be a witness examination or not, or expert examination, post-hearing submissions, including statements on costs. And something that I am very keen on and that I recommend including is rules on additional submissions. And why is this? Well, this is to prevent two tricks mainly. The first is to surprise opposing counsel with last-minute submissions, which can happen. And the second is to have the tribunal see a document at the end of the proceeding, right? I am all for front-loading, but I work mostly with Latin American countries and Spain, and that's not always the case in this legal tradition. And so in order to make that possible, I make sure that I include a rule on how the tribunal or the sole arbitrator, whatever the case, is going to deal with additional submissions, just to make the parties know the rules from the outset, right? And I think that this is especially important in your first appointments, because as Rahul said, normally first appointments are smaller cases in which parties may not be very sophisticated or very used to arbitration. And so, having clear rules really helps level the playing field, especially when you have unequal counsel, one that's very experienced and one that isn't, or when both are not very experienced in arbitration. So that would be my main recommendation.
Thank you very much, Krystal. This is very useful, not just for arbitrators, but also for counsel who are seeking to agree a PO1 or details of a PO1 with the other side. One of the benefits of institutional arbitration, such as ICC arbitration, as opposed to, say, ad hoc arbitration, is that you've got support of case management teams and case counsel from the institution. And often at the beginning of your appointment, you might be having such communications with the case counsel. So do you have any advice, Anina, for how you will go about to communicate with these case counsel from the institution?
Yes, so hi everyone, and thank you also to the ICC YAAF on my behalf for the invitation and for allowing me to be a part of this discussion with you today. Well, the communication with the institution, it should be pretty self-explanatory, right? But you would be surprised how many different approaches there are. If it's your first appointment, I think you need to balance the fact that you shouldn't be scared to reach out or to show them that it is your first appointment and that you haven't done this before, because even more experienced arbitrators come across situations that are first timers for them. However, you shouldn't use the institutes as a crystal ball that will answer all of your questions, because that's not what they're there for. They are very helpful, and there is a wealth of resources available for arbitrators, and they can definitely point you in the right direction. But the tribunal still needs to figure out, and especially if you're sitting as the sole arbitrator, you need to figure this stuff out by yourself and take ownership and responsibility for it. And you can't be calling the institute all the time. For instance, in my first case, I had multiple parties spread across Europe and outside of Europe, and I had never even, my main focus was on the proceeding and writing a good award and it being enforceable, and I never even considered how, this aspect of the parties being in different countries and me being in a different country affected, for instance, the VIT on the invoices that I needed to send after the award was written, or at the same time, basically. And that's surprisingly difficult. And I made a mistake by not asking the parties that had a VIT number. I mean, first of all, you need to ask, does a party have a VIT number? And if so, you need to make sure you get that, preferably already in the PO. Otherwise, there can be a very strange situation at the end of the proceeding where you need to go back to the parties and ask for this type of information. So just keep in mind that, and also count in the time, there are dealings between an arbitrator and the institute after the award is written, or just before you're done with it, that take time. And often, if you're in a pressed schedule, you kind of expect immediate response from the institute, but that's not reasonable either. So you need to basically count, usually it's indicated by the institute approximately how much time different aspects take, for instance, scrutiny, or whether if it's relating to setting the final costs. So that's one important point as well, I think. And then, when you're dealing with them, always be professional and polite. This should be self-evident, but unfortunately, I hear from the local institute here in Stockholm, from the SCC, that unfortunately this isn't the case, and that's, to me, that's quite surprising, because you quickly do gain a reputation, and that's not something you want in this field, especially since international arbitration, it's a big community, but at the same time a small community. So that's important to remember, to keep your cool under pressure. So basically, when it comes to communicating with an institute, I would say, have a good flow communication with the institute, but don't overwhelm them or expect them to take decisions on your behalf. And also consider the time, give them time to come back to you, and consider that time in your own internal timetables. And then lastly, the third point is to make sure you communicate with the institutes in a very polite and respectful manner.
Thank you very much, Anina. Speaking of keeping one's cool, so as we move on from, the initial stage of getting ready for the arbitration to kick off to everything being in full swing. Now, as counsel, we can sometimes be frustrated by what we consider to be unreasonable behavior by our opposite number. And where necessary, we may even choose to complain to the tribunal about such behavior. As the tribunal or as arbitrator, you must then be the one to resolve such arguments. So, Tomas, perhaps you could give us some insight on how you might have dealt with some difficult or perhaps overly combative or zealous counsel who have appeared before you.
Sure. Well, I've heard mention from a number of people of the kinds of scenarios we might expect when dealing with some of our early appointments. And I would add to that, before answering the question, that not only do you deal with potentially inexperienced counsel on both sides, but you may have one side that has counsel and the other side that has no counsel. where the individuals representing themselves or the company representative is not a lawyer, but is acting on behalf of the company. Or you may have in-house lawyers who are not external or arbitration specialists, or not private lawyers at all, but just corporate counsel who are bringing a claim or defending a claim. So the inequalities are even greater than just perhaps experienced counsel and inexperienced counsel. It can be wildly unequal in that respect. And of course, we still haven't talked about, and I think we will talk about non-responsive parties. But with that, laying that groundwork, if we talk about combative parties, think about anyone you might meet in the street or on public transportation, and that person is now in the middle of an international arbitration and has no experience of it. They may be resistant to the concept of why we have jurisdiction over this dispute, why we are asking questions of them, why we are setting deadlines. So all of this could be a completely new world. And of course, we're sitting here looking very nice in our Zoom session, but these are people who don't necessarily have any exposure to the world that we're in. So it takes patience, and you have to really take the time to express things clearly and establish authority of some sort. But I had worries in my first appointments that I appeared too young, and I was dealing with industry people who would be questioning me at every step. But if you take the time and explain that, they're here on the basis of a contract, which they agreed to, that is, we're assuming that there are no jurisdictional objections. But if you set the groundwork and patiently explain why you're there, things tend to go the way you want them to. If it happens that there are spanners thrown in the works halfway through the process or towards the end, luckily, I'm looking at very experienced counsel and arbitrators on this Zoom panel who know how to navigate those kinds of situations. They can explain, well, if this happens, then this is the consequence, and just very patiently explain the situation. So that's the way I've navigated those kinds of situations.
Thank you very much, Thomas. That's helpful. It's good to know we should always just be patient and explain things in full. However, as life always takes us in unexpected directions, there are often delays, sometimes out of the control of counsel, sometimes within. But have you had experience with parties that are, for example, consistently late with submissions? It's not just, one particular incident, but being consistently late. And how do you deal with them while maintaining your cool? Krystal, do you have any advice for our new arbitrators?
I did have a case in which I think it was my second or third appointment, in which the party appeared and disappeared and had not designated counsel. And so it was frustrating from the point of view that they were we knew, or I knew that they were receiving all communications, which is the main focus when you have a party that is in default or that hasn't designated counsel, to make sure that they are being properly notified of all the procedural steps at all times. But it was also frustrating when they did appear, because they normally had missed the deadline. So I mean, in that case, wanting to make sure that both parties were on equal terms, we gave more time for the party to make submissions. They ended up not doing them, and so it becomes a very frustrating proceeding. And my advice, or what I took from that case, in which there were both delays and a party that was truly in default, even though coming and going, was that notification is the key. If in all the cases that I've had, thankfully we've been able to notify by email, because we knew the proper email addresses and the party responded from that email address, and we made sure that we knew they were receiving the communications, and always asked for the possibility of having the delivery notice and the red notice and everything, which is something that I recommend. But proper notification would be the main issue from a enforcement perspective for the awards to be solid, right? And so it's hard to keep cool. It's hard to sometimes the arbitrator or the tribunal is put in a very difficult position, especially when deadlines for main submissions have already passed and the party wants to make submissions in a belated way. But it's for the tribunal to decide in each case whether that's possible or not, what are their circumstances, and whether you should grant them or not. I mean, I know that I'm not completely answering the question, but it truly comes down to a case-by-case scenario, and how you try to combine due process with the enforceability of the award.
Thank you very much, Krystle. That's a helpful insight. What about interlocutory applications, which we sometimes also get a lot of? And as Krystle said earlier, in PO1, you might have certain provisions for unexpected submissions, but if you have applications that come in, say once a month, what do you do? How do you manage that while still maintaining, obviously giving the parties a fair share, a right to be heard? Rahul, do you have any tips and tricks for us?
Yes, well, I mean, again, everything kind of depends on the facts of the case, but I found usually a four-pronged kind of strategy to help. The first is be fast. The second is be decisive. The third is call for a CMC, asking for the client's representatives to be present. And fourth, and this is really at the end of the spectrum, is threaten costs. So when, and let me explain each of those in detail, right? If you receive if you're receiving several of these applications on a periodic basis, one of the reasons for receiving them could be that the parties want to destabilize the arbitration. And the only way to really combat that is to be fast in the way that you address them. It doesn't mean that you need to provide very colorful and detailed reasoning, but you need to address the application quickly. And that then sends across a message to the council that, their efforts as destabilizing the arbitration are not going to work. Related to that is to be decisive, in the sense that if you are coming to a conclusion about something, then say so. Very often I find that there's a bit of hesitation in deciding this way or the other, and then the rulings of the tribunal are a bit, how do I say it, gray, instead of being very clear. And that then is fertile ground for launching another application, a few days later. So if you have decided something, say so clearly, be decisive, and then you will find that once the parties realize that you're not a pushover, that you're not going to be easily swayed by the volume of applications, they'll just simply stop making them. The third strategy, I would say, is call for a case management conference. I often find that lawyers, especially inexperienced ones, are very happy to send out written applications and write lots of things. But when you ask them to come for a case management conference, when they're faced with you and they're faced with the opposing party, they are a lot more reasonable, or the positions that they take at least are a lot more reasonable. So you can cut away a lot of this, procedural grandstanding if you simply call for a CMC. And if you really want to be even more severe, ask for a client representative to be present. And then the client representative being there in the room or virtual room with you and counsel will realize that, look, the tribunal is being kind of fair. The tribunal wants to keep this arbitration moving along. It's my counsel that's being obtuse. It's my counsel that's trying to kind of move things or skewer things. And that's not really helpful, because I can see that the tribunal is not, getting impressed by these tactics, right? So it's useful to have to ask for a client to be present. And even if the client can't be present, at least you have a written communication to the parties asking for that. So then, in a way, you're sending a signal to the council to say that, you're on a short leash here. We're going to not tolerate this kind of conduct for a lot more, or for a lot longer. And the last thing is, and I find this always helpful, is to threaten costs. And you don't really have to impose costs immediately, although you could. I find that to be quite drastic when the arbitration is still ongoing, but you could definitely threaten it. And you can, a seemingly innocuous line in your correspondence to say that, there have been a number of procedural applications which have been made over the past, and the tribunal will keep this conduct in mind in its eventual decision in allocating costs, something like that. And I think that is also quite useful in kind of signaling to the parties that, this kind of, repeated application conduct is not going to be very quick. And in terms of applying this, I found this to be quite useful in my first ICC expedited arbitration. There were two respondents, and the tribunal, which is the sole arbitrator, commonly is appointed, which was me. And immediately after appointment, I received an application from the second respondent saying that they wanted a bifurcation, because they said that the tribunal has no jurisdiction over the second respondent. Now, having a bifurcation in an expedited context is almost, impossible. But okay, we went through the motions, and I asked the claimant to comment. The claimant did, and obviously opposed that position. And then I issued, a ruling that said that we're in an expedited context. We're going to have a decision issued, and I'll consider the jurisdictional objections along with. I'll issue one award that would also address the jurisdictional objection. So I rejected bifurcation immediately, but I think the application was probably prepared and waiting. Maybe a few hours after I issued that ruling, they moved an application for security for costs, saying that, we have to expend costs now because you've ruled in this fashion. And we'll have to take a position on merits when we shouldn't be a party, and therefore we want immediate costs. So it kept coming, and when you're in an expedited context, you're a bit unsure of how to deal with these, because you do need to build in time for the opposing party to react, and then time for you to reflect and then decide, right? So it does happen. In that particular instance, I mean, I rejected the security for cost application as well, but I was very close to saying that we could have, we have a hearing anyways, again, in an expedited context very soon, right? But if you want to have any further procedural application, then I'm going to call for an immediate hearing. And I think even just, it's easy to do now. It's not expensive. It's a Zoom call, or any other platform. But just the threat of having to make those, repeated applications in person as opposed to in writing, I think does away with a lot of them. But yeah, that's what I would suggest.
Thank you, Rahul. That's very helpful. It also sounds like it may have been a little stressful for a first-time arbitrator to be bombarded with application after application when you're a junior member. And so as first time or
Krystal,
sorry,
can I just add something, because I think
of course.
that, I mean, one of my a close friend of mine that's an arbitrator used to get very nervous whenever they got any type of petition that was not called for, right? And I just want to tell the people attending the seminar that it's normal. You can get nervous, but it's okay. You don't have to make a decision right there. You have to listen to the other party. So your instinct should be forward to the other party. You need to hear the other party. You want comments, and then you have time to think. So don't get nervous when this happens. It will happen. And the only thing that you have to do is listen to the other party. So you have time.
Thank you, Krystal. That is it. I mean, having that breather room, I think is certainly going to be valuable time for a newbie arbitrator. And as a newbie arbitrator, sometimes you may be running into unfamiliar issues or situations like the one Rahul has just described. And aside from tuning into webinars like this one, you may need some advice from your colleagues or more senior members of the community that you may be familiar with. So Anina, can you give us some advice on how you can ensure confidentiality of the proceedings that you're taking care of when you are getting such advice?
Yeah, sure. Happy to talk about that. I mean, first of all, I just wanted to comment briefly on what Rahul and actually also what Tomas said before that, and Rahul and Krystal now, is that I always describe, you know, your approach to these things as a intricate dance between party autonomy and basically a nun, a Catholic nun with a ruler. And that's how I see the role in essence. It's like a tango dance where you, you know, you dip towards listening to the parties, and then you dip towards the nun, and you need to kind of adjust depending on the situation in that sense. When it comes to talking about your cases, I mean, obviously that's not something you can do, or seeking advice. I don't know if I've ever done that actually, but definitely, I mean, it's good to sometimes sanity check things. If you have another colleague at your firm who sits as arbitrator, you can definitely sanity check something on a general level, but I wouldn't ever give out any details, neither when it comes to the material issues, how I'm going to deliberate, or anything like that. So it's the key to maintaining confidentiality is to keep things confidential, essentially.
Thank you, Anina. I'm conscious that time is running away from us, and so I want to move on to dealing with complex proceedings. As we know, even from counsel work, arbitrations today, even smaller cases are often not a straightforward one claimant, one respondent situation in one arbitration based on a single contract or claim. Have you had experience with parallel proceedings, either multiple arbitrations or arbitration and litigation, and how would you manage such circumstances? Tomas, do you have any advice for us?
Sure, nothing earth-shattering, but I am in the middle at the moment of dealing with two parallel arbitrations as sole arbitrator, and they're between the same parties and just in respect of slightly different agreements, in both cases financial agreements. And so the tip, the earth-shattering tip is to keep the facts straight, because each arbitration needs to be standing alone. Each award is going to be a standalone award, even though the underlying facts are nearly identical. You need to keep track of what were the dates in respect of the correspondence on one agreement, what were the dates in respect of the other, were any representations made on one side or the other in terms of those agreements. So it's really making sure you get the details right, because ultimately you're trying to get to an enforceable award, and you don't want to make a simple mistake that could lead to problems down the road.
Thank you very much, Tomas. I mean, it is basic advice, but I think really worth keeping in mind, even for arbitration counsel who may be managing parallel proceedings like this on behalf of a client as well. And when it comes to hearings, sometimes we've got your, day-long hearing on Zoom, but sometimes we've got a 2-3 week hearing that may be, very draining for both counsel, but also for the arbitrator. From your experience as arbitrator, what do you find particularly useful to receive from parties in preparation for such long and complex hearings? Do you like chronologies? Do you find them useful? Or how about agreed statements of fact or skeleton arguments, which are, I guess, probably more common in the English or common law world? What are your favorites? Rahul, do you want to kick us off with that discussion?
Sure. I mean, I think all of the documentation that you mentioned is useful, right? But eventually, at the end of the day, it shouldn't distract the tribunal from its main role, which is to kind of, digest all of the information which is presented. If you're thinking about your first few appointments, it's unlikely that you're going to be faced with, thousands of exhibits and thousands of pages of submissions. So I think you have to be a bit careful about what you request for and whether it's really needed or not. What I genuinely dislike, and I would discourage any kind of budding arbitrator or new arbitrator from doing, is to kind of throw up on the parties by way of a surprise, some documentation a few days or weeks before the hearing. I think that is not very good treatment of the counsel. So like a week before the hearing, to all of a sudden surprise them and say, oh, in 2 days, I want you to have a skeleton submission, or I want you to give me a summary of your important evidence, or anything which is kind of has not been contemplated earlier, which the parties haven't had the opportunity of kind of factoring into their own schedules, I would avoid doing. So in terms of what I find to be most useful, provided that it's kind of again discussed with the parties beforehand, I think a chronology is very useful. And I kind of like the parties to liaise with a joint chronology. When there's a disagreement, both parties' positions or both parties' kind of description of events on the day goes in, and it's highlighted in a different color. So blue for the claimant, red for the respondent. Both go in, and you still have then a full picture of that. If that chronology, without causing too much of a burden on the parties, can be cross-referenced with exhibits, great. If those exhibits can be hyperlinked, even better. But all of this comes at a cost, and all of this takes time. So I think that you can ask for these kind of submissions, provided that the parties have had, the parties are aware that they have to be submitted in advance.
Thank you very much, Rahul. Certainly from counsel's perspective, it's good to know that arbitrators can be considerate about this, because clearly these things, especially when you need to agree with the other side, it often takes a lot of time. And when you're, in the lead up to the hearing, when you're busy with, a million other things, this can be a significant burden on, a team's resources. So, certainly advance notice would be most appreciated from counsel. Do any of our other panelists have any other favorite documents that they would like to share when it comes to hearing prep for the tribunal, or any comments on this topic? Krystal?
I agree with what Rahul has said, and in my experience, in my first appointments, it really wasn't justified for me to go back to the parties and ask anything further that had already been presented. And in the end, you can have all the agreement that you want on facts, but you still need to study the case. And so my approach was to study the case very closely, even the exhibits, and go to the hearing very well prepared to pose the questions that I had to counsel, without asking any further from them, because the cases did not justify it, and the workload did not justify it. So, it's unlikely that in your first cases you would need, unless it's a very, complex construction case, for example, in which you would need in those cases, I normally do like to have an agreed timeline, for example, or at least a timeline of everything that happened. But other than that, I think that it's for the arbitrator in a smaller case to just study the case and go to the hearing very well prepared.
Yeah, I could just add something to that. For me personally, if it's a very fact-intense case where there's rebuttal upon rebuttal and so on, and a lot of evidence in the case, I find skeleton arguments very helpful if the parties agree to it and you agree on it in good time, so that it doesn't come as a surprise, like Rahul accurately pointed out. And also in that context, ideally to point out the main evidence. So you have the claim, the main arguments, the evidence that's invoked, and then also kind of give a heads up that you want in the closing statements to hear what they think about the burden of proof and how that should be divided.
Thank you very much, Krystal and Anina and Rahul, of course. Turning now to some of the questions we've received in the past 45 minutes through the Q&A chat box. I'm not sure if we have time to go through all of it, but maybe just one or two. Panelists, how do you deal with or decide the case of an unwilling party? If a party is unwilling to appear at all and doesn't submit any arguments, how do you manage? Would you decide purely on the submissions of one party? How would you potentially be a little more interventionist about asking questions? What has been your experience?
I'll jump in. I would say a big proportion of my early appointments have been exactly that, where it's often an institutional appointment where one of the parties is non-appearing at all, and you have to take extra steps to make sure that both sides effectively are heard. I would say that task is often given to newly starting out arbitrators, but is probably a more difficult task that should be given perhaps to more experienced arbitrators. So things are a little bit upside down there. But it's a baptism by fire. You learn that you have to probe all of it's the claimant's submissions that need to be probed. So you'll be asking questions to them. You'll be putting your hat on potentially as counsel for respondent and making sure that all of the relevant questions are being answered. So even when things seem simple, I will include in my procedural orders or procedural timetables scope for the proceedings to be closed, subject to perhaps new questions that I might have. And I put the parties, usually the claimant only, on notice that as I review the materials and I'm drafting the award, I may realize that certain issues have not been sufficiently covered from both sides, and I need claimants to take a position on what the respondent might have said here.
If I can add as well, Krystal, sorry, I didn't mean to,
Of course.
to interrupt. It's exactly as Thomas said, right? When you have your first couple of appointments, it's likely that you're not going to have the respondent might not might not appear at all. I think it's especially important there to have reference to the procedural framework that you're in. So most procedural rules will say that in case of default, you have to continue on with the arbitration. So I think it's useful to set that out to the parties that irrespective of the non-appearance of the respondent, or at least one of them, you're going to nevertheless proceed with the arbitration. I think it's also important to invite the respondent repeatedly, and at least I do this, and I have done this now in a case that I'm currently sitting on, where, you know, in every communication that I write to the parties, I say, the respondent hasn't appeared, I invite it to appear and express its position. Because then when you write the award, you can say that, you know, on multiple occasions, the tribunal invited the respondent to attend. And the respondent nevertheless chose not to. I think it's important also to have a record of the sending of the communication, right? So whether you're sending it on email, whether you're sending it on via hard copy, at least the important communications need to be sent. The first tribunal that I chaired was a domestic arbitration in India. The respondent did not appear. And with my colleagues on the tribunal, we decided that we would designate, well, the claimant, our ideal position was that all communication should be sent via hard copy. The claimant wrote back and said that, look, this is expensive and time consuming, and we don't think that it's appropriate. The respondent is not going to participate. So we then had a deliberation to decide what would be the best way forward. And we decided that some communications that we as a tribunal designate should be sent via hard copy. And throughout the arbitration, because there were multiple issues that arose, we had to, we designated some communications to be sent. Now, the award was issued in favor of the claimant, and the award was subsequently challenged. And it's the first award I've ever had of mine being challenged, and my heart was literally in my mouth, so to speak. But I was very happy that the Bombay High Court at that time went through exactly what I've just mentioned, to say that the tribunal has sent the important communications to the respondent. The respondent chose not to appear, and we believe that that's enough, and nothing more could be done. So I think that it is important to show, to potentially either your setting aside court or your challenge, or the court where enforcement is sought, that you've done everything that you could to have the respondent participate. It chose not to participate, and you've continued on with your mandate to get to an award.
Thank you very much, Rahul. As we are fast running out of time now, I'd like to ask each panelist to provide us with one concluding piece of advice for first-time arbitrators. If you look back at your first appointment, what would you tell yourself? Let's try to do that in maybe 30 seconds per person. We'll go from Krystal, to Anina, to Tomas, to Rahul on my screen, please.
Great. I'll be very brief. I think that if you get worried about procedural steps because you're not familiar with them, my advice would be to consult with administrative counsel from the court or from the institution. They are always very happy and eager to help. And so don't hesitate to go to them. I would say go to them, stay calm, and you can do it.
Yes, I'll just jump in here with my concluding advice. So my leading principles as an arbitrator is to set a firm framework for the proceedings so that you keep the timetable, and then to make both of the parties feel like they've gotten to present their case in a manner that they're satisfied with. And how you do that in practice for me is I make sure I always have a cutoff date, and I make sure to make it very clear, especially to parties who are, you know, not that experienced, who come in with unsolicited submissions or late submissions, to say, look, this is the deadline, nothing goes past this, basically. And also to set this cutoff date in good time before the hearing, so that the parties have time to, the council really has time to prepare, because that's best for everyone. And then not to make the proceedings look like you, but to basically listen in, depending on the legal cultures that are involved, what is it that the parties want, and that's the party autonomy part. And then when needed, you bring out the Catholic nun with the ruler.
I will try to answer questions as part of my concluding remarks. I will say my concluding remark is start drafting the award as soon as possible. We had a question from James Wagner on that point. I think it helps stay on top of the procedural history if you already have a document open as you start the proceedings to say, I was appointed on this day, I received this submission, I received those documents, and you just go down the list and you're already drafting part of the award, which is the procedural history. And then when it comes time to sit down, you already have half of the thing, if not more, done. So James, draft from the beginning.
And my advice would be simply, it's something I said earlier, don't be afraid to be decisive. You are, you know, very often when you have your first few appointments, you second guess yourself. There's no reason to. If you've read the file and you're sure, I mean, to the extent you can, the decision appears to you to be reasonable, then it is probably reasonable. Don't be afraid to be decisive and to communicate that decision to the parties.
Thank you very much, panelists. I don't think we have a little like remote clap button on this Zoom call, but I will thank our panelists on behalf of all the participants for what has been an insightful and interesting hour. I am sure we have all picked up a lesson or two, whether for a budding career in the tribunal hot seat or getting some tips on how our arbitrators think and work. I now hand over to Natalie to close off the session with reminders. Thank you.
Hi there, thanks ever so much, Krystal, and thank you all to our panelists and to also Nora and Trisha for helping to put this webinar on. I think it's a great start to our two-day conference. And with that in mind, we have another webinar, two webinars actually taking place today. The next one is on insolvency at 12 o'clock, and then the next one after that is at 1:30 today, all UK time, on expedited procedures, which is going to be vastly interesting. So I do encourage you to attend those. You would have all received the webinar instructions with the links. They will be going around again for any people that have registered last minute. We had 85 people today in today's session. So thank you everyone for joining, and we look forward to seeing you later on today. Thanks ever so much. Bye.